Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Ways down and ready to ride. One by 1 billion by billion is holding up half the sky. Raise your hand if you're ready and willing. If you know it's time. Time for a girl on time. Time for a girl on time. Time for terribly prepared. I just said that. I'm terribly prepared for this live stream. I apologize. I'm not wearing any makeup. I'm sure you could tell. Because I don't know, my eyes are really, I think I am having some allergies along with my whatever cough or cold this is. Now, I promise you that the way I look right now has nothing to do with the story I'm about to tell. But do I look that pale? Hold on. It could be different. Hold on. Better? A little bit better? But again, I'm wearing no makeup. But my eyes are really, really red and sensitive right now. And so I just didn't want to put makeup on my face all over. But on another note, I totally forgot, but my ex-husband is getting married tomorrow on a Thursday. I was like, how unique. Excuse me. Anyways. But I promise I have not been crying about that. I really don't care. I'm actually quite happy for him. Yes, heroin PM. No. But yes, congratulations to my ex-husband. I honestly didn't know you could get married on a Thursday, but of course you can get married on a Thursday. Of course you can. The other thing I wanted to talk about is, and I'm not invited. No, I'm not invited. That's okay. I was barely invited to my wedding. Okay, so the other thing I was going to talk about is last night I saw this. It was a TikTok video on a YouTube short. I really don't use TikTok that often, but it was a TikTok video on a YouTube short, and they were talking about something specifically called amylase, which is like an enzyme that is secreted by your mouth and your pancreas, and sort of determines how you process carbs. Now, this sounded very TikTok-y to me, and I was just like, because basically this TikTok was like, if you take a saltine cracker, an unsalted saltine cracker, and chew it up in your mouth and time it, the amount of time it takes for it to turn from like salty to sweet reflects how much carbs you should eat. Now, scientifically, this is actually a thing. But of course, I didn't have saltine crackers. So I looked it up and I was like, well, damn. It also says here you can use a potato. So a raw potato. So I shit you not. I thought about this all night. I wanted a saltine cracker so bad to try it. Didn't have one. Like, I just love testing things like that. But of course, I'm not feeling a hundy pea, so I'm not really like out to walk to get some saltines. So I do have potatoes though. So this morning, pretty much first thing this morning, I woke up and I was like, potato time, let's do it. Cut out my potato, no peel, just the middle part of the potato. A piece of it, raw. And no skin, Now, I have yellow potatoes. I looked, it didn't say anywhere that the type of potato was important. But I chewed on the potato and it never turned sweet. And now I'm concerned and convinced until I get a saltine cracker and I'm able to do the proper test that I am one of the people that has no ability to process carbs, which would make a lot of sense. And but so basically boneless skinless potato. But basically you take like the saltine, and apparently like the flavor changes. I remember saltines tasting sweet when I was little. I do, in a way. Also, we don't call them saltines here. What do we call them? Well, we call them by the brand name. Like if I wanted somebody to pick me up what you guys call saltine crackers, I would say, hey, can you pick me up some Premium Plus? Which I think for Premium Plus crackers, which I think is owned by Mr. Christie, but I'm not sure about that, is probably a win on their behalf. But I'm talking about, oh, saltine is a brand name? Oh, I thought saltine was generic. Wait, what is the generic cracker called? You know the ones that come in the little like 2-pack at a restaurant when you get soup? And no, my whole mind is blown right now. I thought saltines were because we don't have saltine brand anything. I'm pretty sure that saltine is like a generic thing. Well, I'm gonna have to go down a rabbit hole about that later. Anyways, am I really? I might even have to make my own saltines, although I don't know if I can do the test with those. Premium is a company there too. Premium Plus crackers are my favorite. I'll tell you my especially favorite part of crackers, a sleeve of crackers, because I used to polish off sleeves of those crackers. Ooh, memories coming back here. I loved crackers when I was younger. Is when one side is burnt. Not burnt, but darker than the other. Soda cracker, saltine. Okay, thank you guys. But anyways, you know when like one side of the sleeve is like just a bit darker than the other, and you can taste it a small amount, a small difference in the flavor. Aww. Then that's my favorite. I haven't had myself a full sleeve of saltine crackers in a long time. I do want to make my own though. I saw this lady recently make homemade Cheez-Its, and they looked really good. She was making homemade Lunchables. I mean, that is such a level that I am not at. I particularly like Lunchables for me as the adult. Anyways, so as I've rambled for 9 minutes about saltine crackers and all the other important things in life. Oh, and my eyes are getting itchy again. See, this is why I can't be wearing makeup, because I'm rubbing my eyes all day and they just are getting red, and there's still mascara on from yesterday because of stupid fucking waterproof mascara. You know, waterproof mascara is great for one day, and then it's just a fucking problem, to be honest. Thanks, Sephora. But yeah. Let's watch some court. Do I have allergies? I think so. I'm sick as well, but my mouth was very itchy today, so I think I probably do have allergies. Fried rice cooking. Bev, the key with making fried rice, I learned this, is you have to use day-old rice, or at the very minimum, cooled rice. So what you can do is, you already know. Well, I'll just finish saying it anyways. You cook your rice first, and then you either let it cool overnight, or you can spread it out onto a cooking sheet, a baking tray, with like parchment paper on it, and that will let it cool a lot faster. And so then you can use it maybe in a couple hours. So you don't necessarily need to do it the day after. Like, day old rice is the easiest because it's achieved the cooled consistency. But the thing is that you just don't want to use fresh rice because it'll break, and that's when it gets mushy. Yeah, sesame seed oil or sesame oil adds flavor, but sesame oil has a very low burning point, and it's not a good cooking oil. It is a flavoring. So you cook it in cooking oil, and then like peanut oil, which has a really high smoke point. And then you go ahead and finish with a little bit of sesame oil, but you don't want to cook the sesame oil too much or it will burn. I just use white rice usually. Lots of egg, green onion. I like water chestnuts. They are great for adding crunch, and they are a really great vegetable to keep in your cupboard because they're in a can. But I love like the crunchiness of them. I don't add shrimp, but you can add shrimp. You can add chicken. You can add anything. But I like water chestnuts. Ooh, baby corns. Onion, of course. Oh, garlic. My favorite fried Chinese fried rice has like 10 thinly sliced things. Thinly sliced things of garlic. Also mushrooms. Yes. Yes, you whisk the egg first. You cook it first, actually. Put the egg in first. So how you do it is put the oil in the pan. You put if you're going to have 2 eggs, you do 1 egg first in, then add the rice, all the rest of the stuff. And then at the very end, you cook the last egg in it. And that way you get little extra eggies, little eggy bit. Okay. Judge Kirkham, take it away, sir. How is Wordle today? Have you got the... Whoa! That's my phone. Don't get scared of it, Paisley. Oh. Hi, guys. I see everyone is rating us along. Welcome to the party. Welcome, welcome, welcome. Thanks for being here.
The 37th Circuit Court is now in session with the Honorable Brian.
With the Honorable KCC. Make sure that you go ahead and clock in for your shift, hit the like button, and go ahead and make sure you're subscribed. We are trying to hit 2K by the end of May, and you can be part of it. So, also, I don't know what this court is, so let's find out together. But thanks all for being here. Love it. Look at all my friends. Okay.
Kirkham presiding, calling case 2021-1898 DS, Jasmine Mosley versus Robert Hollins. Today is Monday, May 13th, 2024 at 10:22 a.m.
This matter is before the court pursuant to the plaintiff's motion to set aside referee recommended order in this matter. The court would note that the referee had ordered some graduated parenting time for 2 months, thereby then after going to standard parenting time. Ms. Mosley, you claim that you want consistency in.
Ooh, this sounds good already. I'm getting yelled at from the kitchen because I left food in. So much. I hope we hit 2K by the weekend. That would be amazing. I would be dancing if we hit 2K by the weekend. Oh, you guys are amazing. MB, missed you too. Also, this is the judge. I gotta go check on this shit I just put in the oven, but you guys gotta fill me in what happens with the judge because I think he's saying something juicy.
Parenting time. Well, the referee schedule would provide you with consistency. So tell me, what am I missing?
I didn't want parenting time at all, but apparently we have to do it. That's what they told me last time. I would like to start off at least with like supervised visitation or something starting off with her having somebody that she can be comfortable with while spending time with him.
Okay. Well, we don't just set aside the referee orders because of what you want. You have to show that the referee made a factual or legal error. So what is the factual or legal error?
Well, I don't know what that looks like. I mean, he told me that I have.
Okay, so this is a great point. Hi, Colin. Thanks for the raid. Oh, Mayor, I love you too, but I meant to click on Colin. Colin, hi, thank you for the raid. This is a great point. I think Colin agrees with me on this. Everybody, I'm sure here agrees. Get a lawyer. I'm always surprised that people can make objections and get this far in the process. And then she literally just said, I don't know. I don't know. Well, she probably should have checked into that.
The right to disagree with what he put in set, and that's what I did. So everything that I listed in the letter, the email that I sent, that was factual to me. So.
Oh, okay. Mr. Hollings, is there anything you'd like to say in this matter?
I just been trying to get my daughter. I actually just missed her birthday because of this motion. So I just really want to try to get to the visitations with my daughter as fast as possible.
Okay. Well, based upon what the court sees in the again in the pleadings as well as the argument today, I do not see where the referee made a factual or legal error. So the court will deny the motion to set aside. That means
denied, but legal fiction. Oh my gosh. Thank you so much. Oh my god. Oh, please make sure you have gifting turned on. YouTube Daddy is super finicky about that. Thank you so much. We do members only on Sundays around here, right after our Sunday Court Watchers Anonymous meeting, which, unlike what it sounds like, we do not discourage people from watching court. Rather, we just talk about how much we love it. Thank you so much. Yes, members only every Sunday. Also, I do see I already got more subs. You guys have got me to 1,922. We are closer every sub. Thank you so much. Dude, he just like denied that super quick. And again, this is why we have you bring a lawyer, right? But she wrote it in an email, Judge. Oh, super finicky. But still YouTube Daddy. Thanks, Bill.
that order remains in place and needs to be followed. If it's not, then the person violating it can be held in contempt of court in addition to other remedies. So at this point, that order will remain in effect. So the parenting time will proceed as provided for in the order. And that will conclude the matter. You're free to go. Have a good day.
Thank you.
I don't imagine that's how she thought that was going to go. Robert, you made the judge disappear. Oh my God, thank you so much. Robert from Cologne in Germany. You guys are amazing. Judge, though, seriously, make sure gifting is turned on. We've had it before where it didn't work, so it's a huge help to me. Oh my gosh, my wrist's a buzzing. Thank you so much. You guys are amazing. Seriously. Whoa, Jesus, that's scary.
Good morning.
Morning.
Good morning.
Good morning.
Good morning.
Oh my God, sorry. That scared me. I wasn't expecting him. I thought I was gonna have to fast forward. Oh God, you guys are so amazing. Thank you again, Legal Fiction and Robert. You guys, seriously. And to all the new subs. I very much appreciate it. Very much appreciate it. Okay. I thought that guy, yeah, let's see what we got.
Do you know if Samantha plans on appearing this morning, Attorney Zhang?
I do believe so.
All right, we don't have her yet, so I will place you guys back in the waiting room. We will wait until she appears.
Perfect. Thank you.
Hey, Cross. Judge is working on his Wordle or his Farmville. Actually, put what game you think the judge, and obviously this is a joke, but what game do you think the judge is playing when he is very concentrating? You know what I mean? Oh, Jelly Beans. You just met me, but you love me already. And don't worry, that's a great thing in a totally nice way. I love you too. Thank you so much. Seriously. And we are a big family around here, so welcome. And we are, you think Minesweeper? Oh, Minesweeper is actually a really good option because I do believe like solitaire is a possibility, right? Oh, Paul, you know, can anybody, well, the regulars around here will be able to name what I call the breadbasket of LawTube, which is Michigan, Georgia, Texas, and Washington State. But in case you are new here, like Jelly Beans, I'm Canadian and I live in British Columbia, Canada. So I am even more in the dark about American court than the average bear. Probably not actually these days. I probably know a little bit more than the average bear about some court, but oh, she got those pictures. I guess those are her kids' like footprints and handprints up there. It's usually like a home craft. She's got that on the wall by her diplomas. You know what I mean? Humble brag, BC. That's right. I live on Vancouver Island. You want the humble brag? I live on the southernmost tip of Vancouver Island, and I can barely afford it. MB, oh my gosh, thank you so much. You loved me in a nice way and a creepy way. I'm hoping that it's not past tense and that you love me still. I know you do. I love you, MB. Thank you so much, as always. Florida could stream court cases 24/7, 365. Oh, Florida too. Yeah, Florida, you know, Florida has its own little place. In the, but for my channel, at least, I don't cover as much Florida court. That's only because I don't have a lot of them that work well for me. I don't know why. Oh, from Seattle, just moved to Texas. Yeah, Texas is great. I love Texas. I have been to Texas last year. I've been to Texas before. I was in Florida last year too. And a certain amount of creepy is probably required around here. That's just yeah. All right, let's see what these people got going on.
Oh, where's Jared? Jared, can you hear me?
Jared?
Yes, I can.
All right, calling case 2014-1428 DS, Samantha Coolidge versus Jared Hankey. Today is Monday, May 13th, 2024 at 10:30 a.m.
Court will note the appearance of Mr. Zhang on behalf of the plaintiff, Ms. Henderson on behalf of defendant. This matter is before the court on the plaintiff's motion to set aside referee order in this matter. Mr. Zhang.
Good morning, Your Honor. I apologize. I was hired onto the case like 3 days before the deadline for filing the motion. So a lot of the details I did not have until I had to file the objection, or I'm sorry, the motion on time. Just to inform the court, one part of the reasons that we're seeking for this motion to vacate is because there are some sufficient. I'm sorry, there's some significant deficiencies in the evidentiary hearing conducted by the referee. My client was not allowed to call any witnesses to show the relationship between Mr. Henke and the minor child. My client was not allowed to present some of the evidence that she wanted to present.
Oh, this is interesting. These are heavy allegations. We know the referees, some of them in these, we've seen different referees. Referee Matthew Hagan is one that we watch quite frequently. If anything, most of the referees I've watched are overly indulgent in people presenting witnesses and seemingly unneeded or irrelevant things. So you're coming in hot here, Zhang, but let's see. Also, I gotta go check on the spaghetti.
Also, the referee overlooked the fact, or at least disregarded the fact that the minor child and Mr. Henke hasn't seen each other for 4 years, since 2020, and even though the parties actually agreed on a graduated schedule, the schedule. The parenting time schedule awarded by the referee is just lightning fast. It is not in the best interest of the child for the minor child to have overnights after just 3 visits. 3 in-person visits with Henke. My client's not asking for no parenting time for Mr. Henke whatsoever. My client is just simply asking for a more graduated schedule so that Mr. Henke and the minor child could be more accustomed with each other, rebuild that relationship before we jump into this full parenting time as awarded by the referee. Therefore, we're asking for the court. Oh, I'm sorry. There's also the issue of domicile. Back in 2018, my client came in court asking for a motion, filing a motion for a change of domicile, and that was granted by the court. The referee stated in the recommendation that the domicile should be with Michigan and shall not be removed. That is also an error that should be fixed. Therefore, we're asking the court to vacate the recommendation order to schedule a full evidentiary hearing in front of Your Honor, and any other relief Your Honor feels appropriate.
Okay, thank you. Ms. Henderson, on that last point that the court had previously granted a change in domicile, why would that part at least not be appropriate?
Your Honor, I did not object to that part. Again, in my response, I stated that it appears to be a harmless error. The domicile has been changed. We have no objection to that. It's my understanding that was possibly a typo by the court. To respond to Mr. Zhang's objection, if he had ordered the transcript and reviewed the transcript as is required by this court, he would have heard and seen that his client was given multiple opportunities to comply with the scheduling order. We had 4 hearings that were continued, and she did not comply with the scheduling order by providing the witness list and exhibit list. Therefore, at the last hearing, she was deemed to not have complied with the order and was barred from the testimony or other presentation of proofs. The claim that she was not allowed to present any evidence, again, is improper because she did not comply with the order, and if any evidence was presented and was objected to, the objection, if granted, was proper and therefore barred the evidence as well. So that claim, Your Honor, is simply Ms. Coolidge not liking the result of the referee hearing and essentially throwing a temper tantrum. I don't know how else to classify this objection because she had ample opportunities to comply with the scheduling order.
Is that a legal conclusion? I don't know how to classify this other than a temper tantrum. Is that what she just said? Also, I'm looking back through my notebook to find, I don't always make, well, I talked about this before. I make notes about stuff a lot, but not always. And sometimes I don't, but that last name rings a bell. It rings a bell. God, a temper tantrum.
And present evidence, but she chose not to. Specific rulings were given by referee Snyder on the record as to the reasoning for the parenting time that he granted. Specifically, the distance between the parties, the age of the child, the amount of control that Ms. Coolidge wanted to exercise and would not agree to any contact between Mr. Hankey and the child were all taken into account, and that's why the parenting time ordered was what it was, Your Honor. It's unusual to see as part of the order that requirement for the parent to speak with the other parent before speaking with the child is unreasonable, yet the referee deemed it appropriate to include it in the order, again, given the evidence that was presented. Your Honor, again, I would ask for the court to deny this motion. There's not any error or specific unfairness that is listed by the objecting party.
So I have a question for any of the legal minds in the chat then. Is this the proper venue to bring this forward? So he's asking for an order to vacate. If this is denied, could they appeal it in a separate motion? Or is this the right way to do it? I ask this because recently we had a case where somebody brought forth the motion. What the fuck was that? And then I can't remember, but it was just the wrong way to do it. And we talked about how judges can, that's what it was. They can amend their own order sua sponte or from the bench within a certain amount of time, but that it can't exceed, is it 30 days in Texas? We're in Michigan, it doesn't matter, Paige.
No transcript that was ordered. The plaintiff in this matter simply did not comply with the scheduling order and does not like the result that followed that. I would not object to an order clearing the harmless error as to domicile, but again, that's the only thing that we would not object to. Further, I would ask the court to deem this motion frivolous, as it clearly would have any legal argument or does not specify what the referee did wrong, rather than simply stating that the mom does not like the parenting time schedule that was ordered. I would ask for the attorney's fees to be granted. For this court's indulgence, I would also mention that in about 24 minutes, we're scheduled with referee Snyder on our motion to hold mom in contempt, because as a result of the order entering, she did not show up to the first two parenting times that were ordered by referee Snyder. She simply refused. And I think the court needs to know that. Again, this is mom's attempt to block any contact between dad and the child in this matter, Your Honor. Thank you.
Okay, thank you.
Oh, she didn't show up with the child. I was like, well, if she doesn't show up for parenting time, that's her own loss. But you're saying she didn't produce the child for parenting time. Different story entirely. That's contempt. Not good, not good, not good. Also, in front of referee Snyder, do I have referee Snyder's fucking Zoom room? Can I get that, please? I'd like that.
Mr. Zhang, if your client, there were 4 hearings, she had multiple occasions in which she could have filed a witness list or exhibit list, et cetera, and she didn't do it. How was she able to complain now when she didn't comply with the scheduling order?
Well, Your Honor, even if your Honor would be inclined to hold my client responsible for not filing the correct witness list and the exhibit list, there's no question that Mr. Henke and Miss Henderson agreed that the minor child hasn't had any contact with Mr. Henke for 4 years. The error is with the referee's decision to discount that fact and to not hold that fact as a central issue to when determining parenting time.
Okay, thank you. Well, just because the referee doesn't agree with the party doesn't mean that it's an error in this particular matter. Court notes that her objections were she was not able to call witnesses, not able to present evidence, and yet she had 4 hearings and none of which she complied with the scheduling order, which required her to disclose those witnesses and those exhibits in this matter. She can't now come in and complain about her failure to comply in these particular cases. So, no, ma'am, you've got an attorney. I'm not going to listen to what you have to say.
He just wasn't informed, so that's why there's things that he doesn't know.
Ma'am, do not talk. You have an attorney. Your attorney will talk for you. So in this particular case, obviously the court does not find whether the referee made a factual or legal error in this matter, except as it related to the domicile. So the court will, again, deny the motion to set aside. That means that order is in place, it is enforceable, and if parties do not comply, they can be held in contempt of court. The court will allow you, Mr. Zhang, to, again, enter an order for the change of domicile. You can submit under a 7-day notice of entry to correct that issue, but otherwise the court will submit an order denying the motion in this particular matter. I'm not going to award attorney fees, Ms. Henderson, only because, again, we had to correct the domicile issue, and as a result, we have done that. So I don't believe that attorney fees are warranted at this time. So
Thank you, Your Honor. May I
that'll be
please
the
ask
order.
ask
Excuse
another
me?
question?
What?
May I please ask another question? Last week,
Sure.
we appeared in front of you on the same case on child support issue, and that issue was referred to the referee for a continued hearing. Again, that was part of the ruling, and the child support ruling on that matter was very clear, Your Honor. I would ask for that issue to also be removed from the referee docket simply because it has been adjudicated, and the objection that Ms. Coolidge should be imputed at Indiana's minimum wage was specifically addressed at the hearing, and that's why she was imputed at the income she was imputed.
That's, yes, go ahead.
We already received the order of referral from this court as a result of the last Monday's hearing. Ms. Henderson is basically trying to ask you to basically try to make a oral motion for you to reconsider your decision. I'm asking your court, Your Honor, to deny her request.
Well, I'm not going to reconsider anything. The fact is, whatever the court did last Monday will stand. It will be the order of the court. So,
Okay, thank you, Your Honor.
okay, thank you.
Have a good day.
Well, that's a good question. So mom's attorney, it sounds like she hired is down here, Mr. Zhang. She got to pay him regardless if he wins or not, I imagine. The other attorney here, Miss Henderson, was asking for attorney fees for her client. If they were denied, then her client still has to pay those attorney fees. That's just the way it is. Attorneys, no offense to any attorneys out there, but attorneys are good at billing. And we learned recently that they bill by the 6-minute increments usually, which I love. Fuck if I had to track my life in 6-minute increments. Oh my God.
You too.
Thank you, Your Honor.
She's gonna be so pissed too with that lawyer. Actually, just judge.
Present.
Okay.
Did Judge get a haircut? He looks suave.
Mr. Magnuson was on this one.
Yes, but
He's not going to?
he's not in my waiting room.
Oh.
So it's 10:41.
Okay.
Please connect to audio. Please unmute. Can you hear me?
Yes.
Calling case 2024-133 DS, Anita Harvey versus Casey Bess. Today is Monday, May 13th, 2024 at 10:42 a.m.
Court notes that this matter is before the court on the defendant's objection to the referee order in this matter. I know your objection, Mr. Best says, well, I want this. Well, that's not a basis for objection because of what you want. It's a matter of did the referee made a factual or legal error. As it relates in this matter, you stated that the referee did not take into consideration another child for which you're paying child support. The court would consider that a factual error in this particular matter. You said that you're paying $668 per month for that child. Is that accurate?
Correct.
Okay. Well, you
Okay, well, first of all, I'm hoping you're not paying it directly to the child. Also, if anybody's wanting to hear of a crazy child support case, I posted one on the channel today. The dude ended up having to pay $1,840 a month for one child. And that was the max amount in Texas. He made $159,000 a year. And that is over the maximum for Texas child support income. So, yeah. And also, no problem for answering your questions. I like to answer questions. I like to talk. We know how that goes.
should be given a credit for that amount in calculating the support obligation. Is there anything else, Mr. Bass?
Well, I would just go back to the time with the child. The time of the child the past 2 months has been 50%, and so that was a factual error.
But the referee granted custody to plaintiff, correct?
Correct.
Oh. Mr. Bass, is that accurate?
Yes.
Okay, why, just because you've had the child more than you had prior to those 2 months, why there's no requirement that the referee affirm and ratify whatever you're going through? I guess I don't see how you're saying that the referee made a factual or legal error just because it's not what you want.
No, if we're everything that the paperwork I filled out, and when they asked us in the hearing, talked about the past year, and in the past year, I've had the child overnight more than the 104 nights.
Fucking right, say Mayor. Flag in the play. Nobody. This must be what docket is this? I told you guys I didn't look at this before. If I had, I would have already made these into a video. All these people that know fucking nothing about why they're showing up to court. It'll make a great video. It's just the judge is like on fire. He was ready too. He's like, and so what makes me think, well, this is good. Let's go to the instant replay, ladies and gentlemen.
It was the most, at the time of that hearing, it was the most recent 3 months. Circumstances changed. I left a job at the other side of the state to move back here for that reason. And me and Anita agreed on a schedule. And since then, it has been 50% of the time. And so that's where it is a factual error.
Okay. Ms. Hart,
Okay. That is it's such a condescending okay that he just said. Lori, by the way, thank you so much for joining us. KCC are something that you get here by participating in the chat, by being live, by gambling. We have some gambling that's involved. You can see that happening. They're totally free. They're completely arbitrary, and they are mostly just for fun. So yeah, if you have any questions, give it a try. There is a timeout. Like when you do gamble, just like it wouldn't logistically let you do it every 2 minutes. Or like every 30 seconds or 2 seconds. So you have to wait a little bit. Also, I rigged slots just to be like real slot machines. They are worse odds than anything else. And yeah. Oh, and if you want to find out how many points you have right now, just go to the chat and type in !points and it'll tell you. Okay, I gotta go get the bread out of the oven and get myself a drink.
Harvey, what's your response?
Yes, please, Your Honor. So we agreed to create a parenting schedule that we both could live with. Mr. Best submitted a schedule as of April 24th. And I agreed that month by month, we will determine what will be in the best interest of the child. So we've only determined April thus far, and May, as a matter of fact. He mentions that he's had the child more than the 104 days. Well, that's not true. I've had some extenuating circumstances personally in my family.
I thought this lady was the lawyer. I think this is the mom. Yeah, those are magazines. None of those are diplomas back there. This is the mom. Yes, and there is, it's fun. It's lots of fun. And also, I just am going to warn you, we also have lots and lots of commands in this chat. If you want to get a command added, just talk to us about it. But we have lots of different ones. Some of my favorites, I'll put in the chat.
With my sister being diagnosed with cancer that required me to travel quite a bit, in addition to my work obligation, which is an annual conference once a year. So I believe we can work out a schedule that will accommodate the 104 days, because our daughter is 3. I'm in the midst of potty training, and I have to have a structured environment to keep that going. So I was under the auspice that 104 days would work in the best interest of the child, and he and I, Mr. Best and I, can determine those days.
Okay. Well, as it goes to your question on the potty training, the court's not going to set a parenting time schedule based upon potty training or teaching them how to ride a bike or anything else that may come up. Again, when there's a schedule in place, that schedule is etched in stone until it's changed. The two of you can change it, that's true. But if you don't, and if you don't change it, then it's whatever the referee had ordered, and that would be the schedule. So,
Judge, may I clarify? The referee left it to us to determine the schedule. There wasn't one introduced.
okay. Well, understand, and maybe the referee wanted some flexibility. I understand that as well. And apparently the two of you have gotten along such that he would be entitled to those particular 104 overnights. I would say, just for your edification, if you can agree to that, and let's say we came in, let's say you allowed him to have no time or very little time throughout the year, and we get into November and he's only had, let's say, 20-some nights or something of that nature. The court's going to give him the rest of those months to make up to the 104. So be aware of that. If you don't cooperate and you don't work it out, then you may go a couple months without seeing the child. So just mentioning that. So you can't just not provide for parenting time just because you don't want to. That's going to hang over your head, and that's what's going to be the order in this matter. So, sir, you had something else?
Yes, I was just, is there a way that we can go in front of someone to help us with the schedule? Because I had presented the schedule. Her first reaction was great. That's perfect. But then, like, we're not at a spot where we can agree. I had laid out the schedule that she initially said was okay, but because of a night being inconvenient, I just not allowed to take my child, and that just, it makes it very difficult. And we're not in an area where we can do that, I feel, on our own, because it's just up to her and when it's convenient for her.
Okay, well, obviously these things get into who's it convenient for. Is it convenient for the person proposing it or the person objecting to it? And I'm not going to, again, say just because she objected and maybe had a reason that it's basically not appropriate. What we'll do is, in this particular matter, if you're going month to month, the court will modify it a little to say the parenting time that's ordered by the referee, that the parties will, in this case, Mr. Best, that you will provide her with a schedule by the 15th of each month for the following month. So in this case, we would not be past the 15th of May. So you'd provide by May 15th, you'd provide her with the schedule that you want for June. Okay. She'll have 10 days after you submit that to her to respond. Well, I won't even say 10. She'll have by the last day of the month, she will have to respond to you in writing, meaning you'll have to get that by the last day of the month. You don't send it out the last day of the month. He has to receive that by the last day of the month. So, and in the event that she does not notify you of an objection within that time, sir, then your proposal is going to again be the schedule that you have to follow. So if she doesn't object, she doesn't send a counter proposal or something of that nature, then your proposal would be the governing one for the following month, and the parties would both have to live with that. If she does object, you still have to try to work that out. And if not, then you'll have to go to the front of the court, and the front of the court will mediate that particular issue. If it got to be too difficult, or month after month, there's always objections and always issues, then the court will put in place a schedule that would be, in essence, etched in stone, that the parties don't have any control over at that point. So that will be the order, Mr. Best. With regard to that, you're going to have to prepare an order which would recite what the court has said here today. By you submitting by the 15th, by the end of the month, that she has to object or make an alternate proposal. And if she doesn't, then your proposal would in fact govern at that time. Okay?
So how do I petition for joint custody?
Well, you can petition for joint custody by filing a petition with the circuit court clerk's office. Okay, right now we're dealing with the referee's order, and what you're going to have to do to modify that issue on the parenting time, submit an order, sir, because again, when you represent yourself, you have to do what the attorney would do, which would be prepare and submit an order. So you're going to have to submit an order. You're going to have to do it within 7 days of today's date for that order to get entered. And if she has a right to object, but only objecting to if it's not validly reflecting what the court said today. She can't object because she doesn't like it or I don't want to do it this way. She can only say, nope, Judge, you didn't order it that way. He put down that for whatever reason, something else in the order. But as it relates to the other, taking into consideration your other child adjustment, the court will refer that back to the referee and the referee will adjust child support accordingly. Okay? Anything else, Mr. Best? Ms. Harvey, anything else?
I would like to add, Your Honor, as we look at the objection to this order, Mr. Best also stated that his monthly income was inaccurate, but he also did not disclose all of his income.
Well,
So-
I don't know that, and if in fact he didn't disclose and there's a fraud on the court, you have a right to raise that by appropriate motion for modification, but you have not filed an objection to that effect, ma'am. So as a result, the court can't consider anything you just choose to bring up at a hearing without providing the other side with notice of that, so.
Well, I was just saying in his objection, he wanted the income adjusted, but I'm hearing you say that that's not going to be a consideration.
It's not going to be a consideration,
Okay.
okay? We're going to adjust the fact that he didn't get a deduction for other child adjustment, though.
Understood.
Okay, thank you. You're free to go. Have a good day.
Thank you.
Oh, it ended. I was like, what the fuck? Also, that was garlic I dropped in my bra. Don't get me started talking about garlic. Also, thank you to any of the new people that have stayed watching me eat. And our somewhat insane chat. I do recognize it is not the easiest place to just waltz into, but we are a friendly bunch, I promise you. Let's put on some more court, shall we? Yeah. I'm going to create frame while I do this, but let's see. Present video file. One at random. Last was 33. All right, let's try this one. This one's the weird fucking lawyer that has that weird thing in her office, I think. Oh no, we're good people. It's just a hard place sometimes, Lori. Hard to explain. Some people get overwhelmed. Oh, that reminds me. Abe Lincoln says, it's Abraham Lincoln, right? I'm pretty sure. Is it Whambulance? Whambulance, maybe? Anyways, Abe Lincoln says, fuck, what was I going to say? I can't remember now. Shit. I'm not really distracted there. I can't remember. Whatever. All right, just hit play. Terrible. Honestly, how weird would you feel sitting in a meeting with this? Oh, Discord has the list. That's right.
The 37th Circuit Court is now in session with the Honorable Brian K. Kirkham presiding. Calling case 2022-857-DS, Shania Krapoff versus Nathaniel Weatherall. Today is Monday, May 13th, 2024 at 9:02 a.m.
Court will note the appearance of Ms. Thomas on behalf of the interveners. This matter is before the court on the intervener's objection to the order dismissing motion regarding custody in this matter. Ms. Thomas, I have had opportunity to review your pleadings. I do note on on page 13 of Mr. Coleman's recommendation and order in this case that he did mention reserving attorney fees. It did not make it into the order, so the court would grant your order reserving attorney fees. You can prepare that order and submit under 7-day notice.
Judge, I think, if I'm not mistaken, we had it attached, I believe. I believe we had to.
Okay. We will check and see that. They don't always, when they're attached, the clerk doesn't always send
Okay.
those up to
If you
it. So
don't have it, let me know because I have it prepared tonight, submitted it at that time, so.
we'll check and see if it's there in the file and then we'll get it entered.
Perfect, thank you so much.
Okay, thank you.
Bye. Bye-bye.
That's it. Wow, you gotta have some more for us, Judgy.
I'm going to bring in. Let me sort. Okay, I'm gonna check.
Zuback?
Zubek. No, not Zubek, it's the business court.
Zubek. When I hear that, I think of Eva Zubek, who is a famous YouTuber. Judge is having a rough day today. Also, you guys, this spaghetti pie, I'm going to call it spaghetti pie. Good night, Bill. Also, hi, Sean. The spaghetti pie, I don't want to be rude, right? Because it was not, I didn't make it. It was brought here by somebody. But I'm pretty sure it's not spaghetti. I'm pretty sure it's ramen. And I feel a little bit lied to. I don't know what to do about it. Because everything about it says spaghetti. It's got spaghetti sauce on it. It's got cheese on it. It's served with garlic bread. It was told that it was spaghetti. It is long noodles. But it is, what is spaghetti pie? Spaghetti pie is spaghetti in a pie dish with the sauce and stuff on top. But these, I believe, are this is just not, I don't think these are spaghetti. It's just not spaghetti, you know? It's got a little bit too much ramen feel. Now, it doesn't taste like ramen. But it doesn't taste like spaghetti. Baked pasta, no pie crust. Yeah. And the pasta's already cooked. I guess it's a casserole. I don't know. I've always called it spaghetti pie. Also, burrito pie. Same dish. You just basically put tacos into a burrito, into a pie dish and layer it. They're really thin. Vermicelli? Maybe. It might be. They might be. But see, it's got the tooth feel of ramen. Maybe it's angel hair. You know, if I fucking mention it, somebody out there is going to tell me what it is and say I'm not being thankful. So I'm not going to mention it to anybody in real life. Also, I think I have some Coke to drink here, and I need something to drink.
Van Eitzen and
What?
it's Polaris Fund REIT
Okay.
versus Evolutions Holding. And Attorney Ostrander is just observing.
Okay, so who is representing on this case? Because I can't tell from all the people that have popped in.
Attorneys, is it Sorbachek?
Sobchak.
Okay, Sobchak is representing Polaris Fund REIT and Attorney Van Eitzen is representing the defendants.
Correct, Your Honor.
Calling case 2024-1304 CB, Polaris Fund REIT LLC versus Evolutions Holding LLC et al. Today is Monday, May 13th, 2024 at 9:05 a.m.
Good morning to everyone. The court will
morning.
note that this matter is before the court on the plaintiff's motion for appointment of receiver. Mr. Zojak, go ahead.
Thank you, Your Honor. Ben Sobchak on behalf of the plaintiff, P73567. I'd like to start off by cleaning up a couple housekeeping items. This matter's moved rather quickly over the last week. Relative to our brief, I'd like to correct two case citation mistakes for the record. Our citation to the Reed case on page 16 should have been the Pettiprint, which was also cited at that same page. Also, our citation to the Receivership Act at page 14 should reference section 2 of 554-1024. We actually cited section 1B. The court, please would note that this all came together rather quickly in an emergency, so I apologize for those inconsistencies. Relative to the timing of everything here, the court would also note that we filed a motion to add a supplemental briefing. We were unable to get that notice up for today, and I understand that, but I would like to note that it was provided to opposing counsel the day I was made aware that they were representing defendants, and that was 2 days in advance of them actually filing their response. And lastly, I'd like to say that, the response was filed Friday afternoon. We have a Monday morning hearing. There's a lot to cover this morning. I'm going to do my very best to point out the thinness of the response on my feet today.
On my feet, Your Honor. Okay, we're into it. We're into it. Also, I figured it out. I don't need to question you guys. Why didn't I think about this before? I'm gonna text the lady that made this dish for me and ask her for the recipe because it was so good. See? Duh. And then she'll just say, you can use this pasta, but I used XYZ. Perfect. That's exactly what we'll do. Oh, what noodle do I identify as? I probably do identify as an udon noodle. You know? A little bit fat and a little bit stodgy. And so, Lori, did you ask when I stream? It's pretty much every day. Every weekday for sure. I take some Saturdays off, very rarely. And then we do 2 shows on Sundays. So there's usually 7 shows plus videos a week. I'm on the West Coast. It's only 7:23 p.m. here on my side. And we've been going for an hour. My longest stream ever has been 9 hours. Was it 9 hours? 9 hours. We've done 8 hours. We've done 7, 6. Sometimes we go hard. So yeah, turn on notifications because I don't know always. I have this crazy boss who is just like pretty willy-nilly about when I work. Just crazy.
But if at any point the court believes that it would benefit from additional briefing in this matter, Pelorus is certainly not opposed. These are somewhat complex issues, and it's a very important matter.
Okay,
So
let's move forward. I've got a lot of hearings today, so all this
Understood.
preliminary stuff I don't need.
Are you saying that you're turned on, Mikey, or that you've turned on notifications? Thank you for being here, by the way. There's another great channel. If you're new here and you don't know yet, you should definitely check out Credence and Mikey. You can find me there during the day, usually. They do the day shift. I'm a West Coast correspondent covering the night shift. Oh, I love it. Oh, Cellulite Yoga Pants is just itching to tell you.
Fantastic. Starting off with some foundational points. The defendants have been in default of the loan here for more than 10 months. There's about $10 million at issue. The loan was originally scheduled to be repaid in April of 23.
Hold on, they didn't settle, Loud, unless you know something I don't. I went to look back for it. I didn't see it. I think they're still coming. That's what she said.
The quiet title action, which is related to this, per the briefing, has been proceeding for 15 months. And my understanding is that defendants or Evolutions has yet to file discovery in that case, which is concerning. And finally, the defendants promised my client that they would settle out or resolve that case by summer of 23. And that has not occurred, which is one of the main reasons for the relief we're seeking here today. I also want to point out a couple of foundational points in the response that I think to the court's ruling here. Firstly, at footnote 6, page 13, the defendants note that defendant Flocken does not have 77% of the equity in defendant EGC, but instead only 7.5%. That is incredibly concerning, as we took a security interest in that equity. The first amendment to the loan agreements, which was executed in August of 22, states plainly that he owns 77%, and that is at page 239 of our entire motion and exhibit stack. The information certificate that was provided at that same time also says 77%, and the second amendment, which was executed in June of 23, affirmed all representations and warranties, asserted that no defaults were occurring, and also affirmed that the loan documents and liens were good. So we're here to talk about waste and threat to my client and their collateral. We mostly moved based on the idea of the implications of the quiet title action, but opposing counsel was kind enough to bring to our attention in their response that apparently our collateral equity interest has also been moved out from under us at some point, or perhaps the defendants were not telling the truth when they signed all three of those documents initially. Either way, very concerning. Of course, Polaris wouldn't take an equity interest or security in 7.5% of the money-making entity in this corporate structure. It only wanted the controlling interest, 77%. So we were very shocked to read that, and I think that that new revelation further supports our motion. Continuing, the opposing counsel notes that EGC and Evolutions continue to pay their debts when due. So that's just not as to their prime secured creditor who lent money to build the entire business. This is also mismanagement. That is our collateral. The money that's being sent to these inferior creditors is our collateral. The bank accounts are our collateral. Admitting that the company is expanding and paying other people but us does not help the defendants in this matter. It is peculiar and part of the reason that we're here today. So moving on with those new things that we've learned as of Friday. We have first argued that we're entitled to a receiver based on our contract. The defendants expressly agreed to a receiver and waived any objections to its appointment in 3 different documents, and this is summarized at paragraphs 113 to 115 of our complaint, and also at pages 9 and 10 of our motion. The defendants should be stopped from arguing anything that they're doing today. They waived all objections as a condition at arm's length to be lent this money, and then for the amendments that follow. Nonetheless, the Receivership Act in Michigan specifically says that we can get a receiver connected to enforcement of a security interest or lien if the borrower agreed to appointment of a receiver on default. This is via statute. We are moving under counts 3 through 5 of our complaint for declaratory judgments as to our position on the collateral. I can't do further than that right now because the quiet title action blocks most of my other enforcement remedies, as is admitted or at least alluded to by defendants in their response. The receivership now is really our only option after a year of not getting paid, and the defendants agreed to this. We presented some case law support. We did cite the Maple Creek case, which, while though it was in Eastern District, it was interpreting MCL 629-26, also a basis for my motion, which is Michigan law, and it says plainly, an agreement in a mortgage to appoint a receiver upon default alone is sufficient. There is little hardship in enforcing the terms of the party's bargain. This is simple at this point. They contractually agreed to this. They've been in default for a year. The law supports this. Now, what are defendants' responses and objections to this? Firstly, they argue that California law applies in this matter, not Michigan law, and so I haven't cited any California law and thus made a mistake. It is true that they cite that the loan agreements are generally controlled by California law, but if you look at the provision they're citing, it says, except to the extent otherwise expressly stated herein. And only a couple of provisions later in that same document at section 1225A, which is at page 148 of my motion and exhibit stack, it says that the perfection and enforcement of liens and security interests created pursuant to hereto shall be construed according to the laws of the state in which the applicable collateral is located. Sub B of that same provision says that Pelorus can bring an action in any jurisdiction it wishes. Now, without question, my receivership request is ancillary to my efforts to execute on my client's collateral for reasons explained already, in which I'll explain more. So, you know.
Hey, Benji, let me give you a little heads up here. I've watched a lot of Judge Kirkham. He doesn't really like the big words like this. He really doesn't need you to over-explain things to him because he's already a judge. And he is already even said to you that he has a busy docket. So please don't. It's probably not going to work out so well. I do find it interesting how the docket is just completely willy-nilly in terms of whatever. My brain is not working today. I can't remember.
The assertion that California law applies here based on the contract is false. And
in between child custody and receiverships and all that kind of stuff. Also, it reminds me at the bank. When I worked at the bank, pre-08 recession, the golden years, as we'd like to call it, as a teenager. And I was like giving people loans and anyways. But sometimes you could go like third title on a mortgage. Like 3 banks might have like third claim to a mortgage. So you have to check and make sure that there's not already a title on that, you know, or on the business or on the collateral. It's interesting to me that they would, but maybe I don't understand what this case is about because my brain's a little bit fried today, Hector. How you doing, Hector? How you doing, Hector?
I think that opposing counsel read closely enough, frankly. But nonetheless, if we do want to talk about California Code Section 564, that's simply the jurisdictional statute in California, which is no different than our MCR 2622. And this provision, although is irrelevant, if you look at the subsections, in the response at footnote 3, they note that that provision contemplates the concept of waste, which is one of my arguments. And it also notes at subsection 9 of section 564 that a receiver appointment is appropriate when necessary to preserve property or rights of any party, including our contractual rights to our collateral and our right to appoint a receiver. So frankly, to sum it up, I don't think California law applies here at all. And I think that that was a bit of a straw man argument. But moving on, the next argument that they present in section B is that California law does not acknowledge contractual receivership remedies. In this instance, they cite to you the Turner case for the proposition that stipulation or consent does not confer jurisdiction for a receivership on the California courts. This is interesting because if you read the Turner case closely, that case concerned a rents and profits receiver, but the trial court exceeded its jurisdiction by ordering more property than just rents and profits to be committed to the receivership. The holding there is that the court exceeds its jurisdiction insofar as it purports to authorize a rents and profits receiver to take into his possession property which is not hypothecated in the deed of trust. Stated otherwise, This court was acknowledging contractual receivership rights in that opinion, and the reference to stipulation and consent wasn't in reference to the contract. It was in reference to the parties' agreement at the outset of the action as to what would go into the receivership. Frankly, this is the implications of Turner were misrepresented in the response. And if you read it closely, it doesn't do anything for the other side here except confirm that that court was again taking action on a contractual promise for receivership. It just went too broadly. Also of interest, they cite the Barclays Bank case for the same topic. However, subsequent cases in California citing Barclays have also said, and I quote, "Receivers can be appointed in all cases where necessary to preserve the property rights of any party," again, sub 9 of the receivership jurisdictional statute, "including when a deed of trust specifically contracts for a receiver upon the borrower's default." I'm happy to provide this case to the court. It is unpublished. The citation can be provided at your request, but the cases that they have cited, subsequent cases in California, again, confirm our position. The long and short of it is California law definitely acknowledges contractual receivership rights if it applied, which it doesn't, but either way. Lastly, on this topic, also at section B, they argue that because the receivership has to be ancillary to other relief, we can only get a receivership after we win our lawsuit. This is a huge leap in logic. Just to point out, why would the Receiver Act mandate bonds if you could never have a receiver until you already won your lawsuit and established all the parties' rights in every capacity? Moving on, they cite the Petiprin case. I did the same thing, referencing that the receivership is ancillary to another claim. Of course, the full quote, if you read that case, is unless specifically allowed by statute. Now, I have 2 statutory cites in play here that would allow this, but that's fine because the receivership is absolutely ancillary to other claims. Let's go to the best authority that the court has in this regard. Again, the Receivership Act at 554-1016 1 sub A says, before judgment, a receivership may be appointed to protect an interest in property that is the subject of the action if it is revenue producing, as it is. In fact, opposing counsel goes out of their way to tell you how much money they're making and how they're expanding and just not paying their prime creditor, which is weird. And if there is waste or avoidable transaction, I've argued a lot about waste in my motion. And since Friday, we've now found out that there may be voidable transactions because they've acknowledged that Mr. Flocken's equity disappeared and also that they're paying other creditors inferior to mine with my client's collateral. So I think the Receivership Act supports here. Moving on, the Fannie Mae Maple Creek case.
Sir, please shut up. I'm not joking. We watch court cases all day long. And I will tell you something. I wish I had more football knowledge so that I could make a receiver joke. I don't know wait. The Kansas City Chiefs guy, is he a receiver? The really famous one? Or is he the quarterback's the one that throws it? I grew up playing soccer and watching hockey. Sorry. All you need is Roll Tide. I know about Roll Tide because of Bistro Huddy. This guy bills by the word, by the way. He does not bill by 6-minute increments. He bills by the word. Mahomes is the quarterback. Oh, well, fuck. So he's the one that throws it. Oh, wait, he throws it. Who does he throw it to? That guy down at the end. I can't remember who it is.
Again, notes that in that subject to the same objection, the holding was the plaintiff is not simply asking the court to appoint a receiver and issue an injunction. Rather, Fannie Mae has filed an action seeking to enforce its contract, note, and mortgage. Again, The idea that my claim is somehow, or my request for receivership is not collateral to our other efforts to enforce our security is false. Let's look at the defaults. The final kick here is that we haven't won our breach contract case, and we've only alleged defaults. Well, the response at page 5 admits that no second extension was provided, and that implicitly concedes that there's a default because that sentence doesn't read because the loan was paid off or because the loan is invalid. And recall, less than a year ago, they signed a certificate saying that all loan documents and liens were still legit. The response at 9 offers that Evolutions will pay interest only to the court pending this matter. That does not feel like the position offered by someone who feels strongly that they do not owe my client money. And lastly, again, the Second Amendment to the loan documents signed by all defendants in June of 23 reaffirms the loan documents' validity and the validity of the liens. So there's no basis in the response for any actual colorable likelihood that they can argue that these loans are not in default, much less that my client doesn't deserve to win on the breach of contract claims. Before I continue, I'll sit down for a minute and let opposing counsel respond.
Before you continue with what? What are you fucking talking about? Is there a way to object to the just verbose vomit that is coming out of his mouth? Seriously, like what? Like, seriously. Still, what I would do if I was opposing counsel would be, Judge, it goes without saying you can deny this motion. I'm not going to waste any more of your time, your very valuable time. Thank you. And that's what I would leave it at. Now, I don't know if that's the proper position, but that's what I would say.
That's really my presentation on the breach of contract topic as it
Oh, okay. Ms. Van Eitzen, I know when I reviewed your answer and response that you talk a lot about the title defects and a lot about the other ancillary issues, but you don't talk much about the fact that your clients are not paying. So why are they not paying and why are they in default?
So, Your Honor, we were paying. They were paying for 17 months. And then as part of the, I do think the title defect is important to note because that was known by Polaris going into executing the First Amendment to the loan documents. They knew that was an issue, and it was expected by both Polaris and by Evolutions that this was a Scrivener's error that was going to be able to be corrected
Okay,
in a matter of months.
regardless of that, why are they not?
Wait, hold on. Polaris? Like that really big company, Polaris? That has some like off-road vehicles? Is that what they're talking about? They make UTVs, utes. Michigan, hey? Yeah, I mean, huh. Good night, Mayor. We'll see you later.
Paying?
They were paying, and then
But they stopped. Why did they stop paying?
They did stop, Your Honor, because Polaris refused to extend additional extensions without additional $120,000 extensions, 2 to 3 months. They wanted to change fundamental terms of the loan documents. They weren't just saying, pay us monthly interest.
Why did your clients then say, hey, we're not going to do the extension. We're going to continue to pay pursuant to the earlier loan documents?
Polaris wasn't accepting. We did agree, or we did say we would pay continual interest only payments, but Polaris
saying that you're going to pay and paying are different things.
Your Honor, it was the understanding that if we were going to pay, Polaris was not going to not claim that they were in default. It was going to be pay, but you're not going to get the benefit of reinstatement of the loans. So we've said, and we've put in our documents, we are willing to continue interest-only payments. We were willing to do that previously.
Okay, why interest only and not the entire interest and principal?
There was no principal payments due,
Oh,
Your
okay.
Honor.
Okay,
And then there were, we did make a $50,000 good faith payment in April. And again, we are willing to continue to make payments. That was never the question. It was all the extra fees and the fundamental changes in the loan documents that Polaris was demanding. And again, no one expected that this quiet title action was going to last as long as it did. And, you know, one of the important things to note is Polaris at any point could have filed a motion to intervene. Never would that have been objected to by Evolutions to involve themselves in the quiet title action if they don't believe that their interests are being adequately represented. Polaris and Evolutions both want the circuit court in the quiet title action to decide that the purchase agreement, the warrant or the legal description that was part of the purchase agreement is the correct purchase or legal description for purposes of this loan. And that remains true. And we are aggressively arguing that in the quiet title case. The quiet title attorneys are optimistic that the evidence that is set forth will go their way, but it has just taken longer than anyone anticipated. And again, Polaris knew before they executed.
Okay,
Did she say their company is Evolution? Because I just looked up Evolution in Michigan, and it is a market-leading developer and provider of products and services for online casino entertainment, baby, which I fucking love. I luckily enjoy watching other people gamble just as much as I enjoy gambling myself, and I enjoy it even more when it costs me no money. So, interesting.
I don't need to keep hearing about this. I want to
May I
hear
respond, Your Honor?
why they're not paying, why they're in default. The quiet title action may be a bump, but it doesn't keep them from paying, and that's what I'm going to focus on.
Your Honor,
May I respond, Your Honor?
In a minute.
Yeah, thank you.
Your Honor, again, we are willing to pay, and non-payment does not equate the necessity of a receiver. Again, the allegations that they're asserting for why they need a receiver is collateral dissipation. They are fully secured. Yes, we're paying bills as they become due because it's an operating entity. Of course, we should be paying those bills. You're allowed to pay bills in the ordinary course of business, and it's expected to do so. Otherwise, we would never get any supplies if you don't pay your suppliers.
How much do you owe to plaintiff for that 10 months where payments have not been made?
I believe interest-only payments are just shy of $100,000. Mr. Sobchak, is that correct?
That's roughly correct, 90 to 100 a month. So I'd say about 900 to $1 million.
Mm-hmm.
If I could respond, if you're done.
I said in a minute. I want to focus on what's owed at this point.
Your Honor,
Clarify, she's saying it's just shy of 100,000 and you're saying 900 to $1 million.
No, it's 100,000 a month, Your Honor. So we're
Okay.
talking at least 10 months. And to be clear, the loan required a balloon payment of all principal in April of last year, which is extended to July, and that's it. So all the money has been due. We sent a notice, we accelerated. Like, my client doesn't have to wait. Like, this loan was underwritten based on time and interest. It is a failing of our portfolio. The opposing counsel's position that they can just renegotiate by stopping paying and using the quiet title action as a shield is exactly why I want a receiver to run that case, because we're not convinced that it's being handled for the right reasons. And opposing counsel in that case for the Howlands seems to support this proposition, which is bizarre, but for the fact that they also don't want to litigate a case that's not being litigated for its purpose, but specifically to box out my client's remedies. And that's
Okay.
why we're here today.
Ms. Van Eitzen, he's saying that there's approximately $1 million that's owed. Why are you at 100,000? He's at $1 million.
It was 100,000 a month, Your Honor, were the interest only payments.
Okay, well, when I asked you how much was owed, I didn't ask you per month. I asked you how much is owed.
I'm sorry, Your Honor. I think it was just shy of $100,000 a month. So for 10 months, it would be between 900 and.
Is your client able to pay the $1 million in those interest-only payments at this point?
As a lump sum payment, Your Honor?
Yes.
I will have to ask. I don't know what their liquidity is. They may need to receive money from investors, Your Honor. I don't know if they've got $1 million sitting there.
They're not allowed to receive money from investors because the collateral is my client's, the equity is my client's collateral. All of the loan documents do not allow you to bring in other equity without approval of Polaris, which is frankly denied because the entire 10 million has been due for a year. So no, you don't have $1 million right now because you've spent it on other things, including bragging about how you're opening an 8th flower room, which is astonishing to me that you.
Is it a weed place? An 8th flower room? Wow, this has actually gotten feisty. But listen, I don't know. It doesn't make sense to me. You should make, if you're growing weed legally and selling weed legally, which I have managed a dispensary before, I've worked in a legal grow before. You can make money doing that, but not if you have a lot of bloat and inflation at your company. That's a lot. Also, if it's $100K a month, like they really should have been saving that to pay it back. And that seems like a big thing she should have known, Elizabeth. Like, you can't get money from other investors. Like, he sounds fucking sure of that at this point.
You're expanding your facility while not paying the person who lent you all the money to start this business. And you think that that actually supports your case right now. You don't have the $1 million because the business is not ever planned to pay my client, which is why I need a receiver to do the right thing for all interested parties now.
Your Honor, may I respond?
Yes, go ahead.
Thank you, Your Honor. Your Honor, growing the business only helps Polaris. They have an all asset security filing on EGC's inventory personal property. So all the additional plants, all the additional lights will benefit Polaris. The increase or the real property, Polaris has a title insurance covering the full amount of their debt. They are not at risk of losing what they are owed. They are fully and over secured. A receiver is a last resort remedy that is only appropriate if less intrusive means are not available to them.
It's appropriate if your clients are in default. So,
Your Honor, but we have defenses to that default. Polaris entered into this First Amendment understanding that there was a title defect
again,
that had to be changed.
Please don't keep arguing the title defect to me because I don't care about that part of the case. I care about what's owed and why it's not paid and why are we in default.
It was continuing. We were paying, Your Honor, until they started demanding $120,000 extension fees every 3 months on top of the interest only payments that were due.
Then there's no extension. Then there's no extension and just follow our agreement. There's extensions aren't free in finance transactions.
Your Honor, I would also go with the receiver. All of their concerns relate to evolutions. EGC has committed no waste with their collateral. They continue to operate profitably and will pay and have agreed to pay interest only payments while until the dispute in the other action can be resolved. A receiver is only a last resort remedy. There are other remedies available that we are willing to make, have been willing to make. They have not been accepted. And there are defenses to the claims that they are making. They have an inherent requirement of good faith and fair dealing that we do not believe that they've met. We are willing to make payments, and a receiver does not resolve any of the issues that they're asking for. There are less intrusive means. If they are concerned with what is going on, which are the only issues that they point to for why appointment of a receiver is necessary, is the actions that are going on in the quiet title case. They can intervene. They have made no allegations of embezzlement, wrongdoing, the typical reasons a receiver is appointed.
I just did because you informed me that your
Okay,
client.
hold on.
moved
Okay,
60 days
I don't need to hear any more, and I don't want to hear any more bickering either. What the court's going to do in this matter is the court notes that the documents all provide for appointment of receiver as well as waiving bond in the event that it's necessary. The court then notes that the statutes providing for the appointment of receiver allow the court to equitably appoint a receiver in this particular matter. And at this particular point, for whatever reason, the defendants have felt that they have entitled in some way to simply stop paying. What the court's going to do is I am going to reserve on the appointment of a receiver at this time. The court is going to give the defendants 30 days to bring all of the interest payments that are owed at this point current, as well as to continue the current interest only payments. If in fact the defendants do not pay the back amount within the 30 days from today's date, and do not make the current interest only payments, then the court will allow the plaintiff to renew their motion at that time, and the court will at that point consider the appointment of a receiver. So Mr. Sobchak, you can
Oh, they need to find that money quick. And they probably shouldn't have built that 8th flower room. The problem with marijuana growing is actually it's not expensive in itself. It's licensing that is very expensive, at least in Canada. The licensing to legally have a grow in Canada on a commercial level, even at the smallest, most boutique level where you wanted to have just one person in charge of every single plant, would cost you upwards of $500,000 Canadian just for licensing. That's not even facility. So the problem with a lot of this is that a lot of this has to go through many steps. Like, it's super cheap to grow weed, but it is well, it's not cheap. Depends if you have a good grower or not, but it is yeah. Also, the money probably is in cash, but they can deposit it, especially if it's a legal business and they have a bank that would do it. But even still, what they would be able to do is pay in cash for other things. Like when I worked at the dispensary where I worked, which was pre-legalization, so they were really not allowed to legally deposit any of the money at all. They did things like prepaid rent at their facility for 10 years. Which is why when they went out of business or they got legally in trouble when legalization came around, the building that they had rented out as the dispensary was still rented but empty for 5 years because they paid for it for 10 years in advance. That's how we used to do it in the back in the day anyways, just prepay for everything. US dispensaries are cash only, really? Well, here they are not. you can use your debit card. I think you can use some. I mean, they're legal, so that doesn't make any sense to me. Anyways, in Canada, you can absolutely use your debit card. There used to be a limit to how much you buy, but they told me that they don't do that anymore. You're allowed to exceed the limit. No credit though. Interesting. They allow credit cards here. They don't give a shit. They don't give a shit.
Do an order to that extent and submit it under 7-day notice of entry.
I will, Your Honor. May I add one thing?
Yes.
I appreciate the court's wisdom in going with this approach. I think it's very fair. I would note that opposing counsel conceded in the response that a receiver could be appointed over evolutions relative to the quiet title case that's apparently causing all this trouble. I would ask whether or not the court would consider appointing a receiver simply for that case now during these 30 days. I feel confident the case won't be existing by the end of the month.
I'm not going to get into another case that is not before the court today.
I understand, Your Honor.
Promotion. So you can prepare and submit that under 7-day.
Thank you, sir.
Okay. Thank you.
Thank you, Your Honor.
All. You're free to go. Have a good day.
Thank you.
That's a good deal. Is everything 25% off? The taxes here kill you on weed. I mean, the thing is though, like back before legalization, I would pay $200 for an ounce of weed. That would be $200 for an ounce. Now I can go legally at the dispensary and buy an ounce of weed for $100. But then there's a 20% tax or maybe even higher. I don't pay attention. It bothers me. That's the other thing I really liked about the dispensaries before legalization was it's a lot easier for taxes and payroll. Allegedly, I don't know anything about that actually. I don't know. Statute of limitations on that.
Oh, sorry, I'm gonna have to put you back in the waiting room. It looks like Attorney Todd left. Oh, there he is. Rebecca? Attorney Todd?
Yep, I'm here. Sorry.
All right, Rebecca, can you hear me?
Yes, I can.
All right, calling case 2023-2020 DM.
Just before you do, with your really annoying voice, I just want to say, yeah, I always, because I'm freaking poor at the moment. Well, I live in a very expensive city. Anyways, but all of these are like legal marijuana. They all have the like disclaimers on them. Warning, the smoke from cannabis is harmful. It's not as bad as some things, y'all. Anyways, but there's lots of different ones that you can get, of course, and you can go way up to like fucking $300, $400, $500 an ounce, really, way more. I mean, the thing is, if you're looking at buying like outdoor weed that is, grown, they would call it grown in the sun. You can get it super duper cheap, but that's not my favorite. I miss like high potency weed. One day we're gonna get fucked up, you guys.
Rebecca Aldrich versus Mark Aldrich. Today is Monday, May 13th, 2024 at 9:34 a.m.
Court will note the appearance of Mr. Todd on behalf of the plaintiff, Ms. Zubak on behalf of the defendant. This matter is before the court on the plaintiff's motion for contempt regarding property. Mr. Todd, have you received and reviewed the answer in this matter?
I did, Your Honor, just this morning.
And in fact, the answer states that the defendant has signed that particular listing agreement. So again, at least that aspect of it is resolved, is it? Don't you agree?
Your Honor, it is, and the reason why we wanted to keep this hearing on was, I guess, two reasons. One, the fact that we needed to file this to actually have him sign that agreement. Additionally, we are requesting that an order indicate he would continue to facilitate any aspects necessary for the sale. We have concerns that if the agreement's signed, that's that, and then he will, in essence, kind of thwart any sale.
Okay, Ms. Huback, any problem with having that to say that he'll further cooperate in the sale of the property?
There's no problem with that, Your Honor. My client's happy to cooperate and he has been cooperating. So I don't think an order is necessary to get him to cooperate. As is reflected in my response to the motion, my client's happy to do whatever it needs to take, he needs to do to follow the order.
Well, what we'll do, Mr. Todd, you can do an order state that further that he will cooperate as necessary to affect the sale of the property, and the court will reserve on the attorney fees at this particular point. Mr. Todd, you can submit that under a 7-day notice of entry.
Absolutely. Thank you, Your Honor.
Okay, thank you. You're free to go. Have a good day.
Have a good one.
Thank you, Your Honor.
No, and you have to be careful of that too. Like the thing is, pre-rolls, if the THC percentage is higher than the THC percentage of the flower that they sell for that product, ask them. And most often they'll either explain to you that it is keef sort of stuff, like they'll put keef in it. Oh, sir. Or it's got other like concentrates in it. Last little quick story, and then I'll shut up for a bit, is when I was in Chicago, it was pre-legalization. I was in Chicago in like 2016, and I was looking to buy some weed. I could not find anybody. I've told this story many times before. We finally found this guy, and he was like, he's like, well, how much do you want? And I was like, we'll take whatever you got. And of course, like, we smoke a lot of weed. So I was like, can we get an ounce? And he was like, an ounce? I don't even got an ounce at my house. I got a tray 5. And I was like, what? And I'm like, again, working at a dispensary, like growing weed. I know my weed. And I'm like, a tray 5? I don't even know what that is. But I'm on the street with this guy. I'm just going to take whatever it is. So I was like, okay, well, take whatever you got and need you to go phone your guy to get some more. And I also had him working on getting me like shatter, because I brought pens for shatter that hadn't been used yet. Anyways, so I fucking open it up, and he's like, that's like 5 joints. I was like, I don't know about that, bud. Anyway, so it's a tray 5 is 3.5 ounces, so an 1/8. Again, that lasted me about 4 minutes. And literally, we met the dude again the next day to buy more weed. And he was like, you guys are already my best customers. And we're like, yeah, dude, more. Like, we need more. And then we met this girl at the House of Blues. And she ended up coming here to visit us one time, which was actually very fun. Separate story for a different website. But we hooked her up with the weed dealer guy too. Okay.
Your name, please?
Attorney Ross Hollett.
Perfect. Attorney Movement? Please unmute.
There we go. Sorry about that. David Jacob Kunkel.
All right. Calling case 2024-1020 DM, Talia Sherman versus David Kunkel. Today is Monday, May 13th, 2024 at 9:37 a.m.
Court will note the appearance of Ms. Oatman on behalf of the plaintiff, Mr. Holak on behalf of the defendant. This matter is before the court on two motions by the plaintiff, one for exclusive use, the other for a financial restraining order. Ms. Oatman.
Yes, Your Honor, I believe that we were asking for exclusive use of the marital home. And as well as that, we were also asking for temporary orders regarding custody, parenting time, and support. That was noticed out with the same exclusive use motion and temporary spousal support motions.
Okay, that may have gotten lost and the clerk didn't forward it some because I had the other two motions.
All right, Your Honor, we did receive a response from opposing counsel on all three motions.
Okay, go ahead.
Thank you. We're asking that the court grant joint legal custody. I believe the other side will agree with us on that provision. We're also asking that they continue their temporary involuntary parenting schedule that they have established between the two of them since defendant moved out on March 30th. He has been residing with his mother, and since he is no longer in the marital home, we are requesting that plaintiff mother receives exclusive use of the marital home. She is willing to make arrangements for Mr. Kunkel to have access as needed, but she would like to be able to have that order that says she has exclusive use. She would also like to be granted temporary primary physical custody of the children, and for the parenting time schedule to basically consist of father having the children on the Sunday and Monday overnights that he's been exercising, the midweek visit, which they've been doing on Tuesdays, and for that to continue as a temporary order. We are asking for $152 a month in spousal support for temporary spousal while my client looks for more gainful employment. And we are asking for friend of the court to issue a calculation on child support or for the attorneys to work out child support arrangements between counsel. Thank you.
Mr.
Is that a joke? $152 a month for spousal support? What is that going to buy? What kind of job does she have? Wait, are they implying that she's looking for a job that she's going to earn $152 a month in? I am so fucking lost right now. Also, one of my favorite pens, Cheryl, I have probably I've probably gone through 15 of these pens, at least 15, maybe 20 of these pens. But I also really like the Evo Plus pen, EVO Plus. That pen is really good for shatter and doesn't get clogged up very fast because it's like a quad core pen. But I've burnt myself a lot. Oh, and I had one that had an electrical short on the back. And it literally would zap me, which I sort of liked, because I'm weird.
Mr. Holak, obviously the parties are separated now. That's different than at the time the motion was filed. You have any problem with the exclusive possession issue?
I don't believe there'll be an issue with that, Your Honor, as long as my client can visit the premises as needed to pick up items of his that might still be there. And of course, to pick up or drop off the children.
Well, there'd be no problem for pickup and drop off of children as it relates to the other. He's going to have to give advance notice through the attorneys before the court will just allow him to come and go to pick up property. So the court will grant to plaintiff exclusive use of the property with that provision that he would, coming to pick anything up that would be cleared through the attorney's offices. What do you say about the continuation of the parenting time schedule that the parties apparently have utilized since March 30?
Your Honor, my client would oppose that as articulated in our response to plaintiff's brief. We would be asking for 50-50 parenting time. My client works, but he still would have plenty of time to take care of the children during the hours that he would have with them. The parenting time at this point was a courtesy from my client to minimize any friction from the separation. However, he loves his children. He wants just as much time with them as the opposing party does. So we would ask that 50-50 parenting time be awarded.
Okay, Ms. Altman?
Yes, plaintiff would like to request that the schedule at least temporarily be what they've been exercising for one reason, because Mr. Kunkel does work at a casino, and so he has late hours and he needs to sleep too, and he cannot exercise parenting time while he's trying to sleep per se, and the children aren't because they're not on the same schedule. And I understand his mother does have daycare, so we're not opposed to him having adequate time with the children. We are opposed to switching up the schedule at this moment.
Okay, well, when the parties have the children in their respective care, they can take care of it the way they wish to. I'm not going to dictate when he sleeps or when he doesn't sleep, so. What to do is the court is going to grant to the parties, it looks like he's been exercising the parenting time Sunday overnight through, it looks like Tuesday, he's had Tuesday overnight as well.
No, he has not.
Well, you said he had Sunday, Monday, and he has Tuesday.
Yes, sorry, my apologies. Sunday is actually just a few hours in the afternoon. It is not a full overnight. Tuesday, my apologies. Tuesday is the midweek instead of a Wednesday.
So Tuesday is a midweek and not an overnight.
Correct, Your Honor.
Well, what the court's going to do is the court is going to grant to the parties a joint physical custody as well. And the court will grant to the defendant parenting time Sunday. We'll run it Sunday. Well, let's do it this way. Let's do it. We'll do Sunday from 12 o'clock noon through Tuesday at 8 o'clock p.m. And that will be his time. The other times will be with the plaintiff. And the court will allow the parties to exchange income information and then calculate support at this point. The court's not prepared at this time to grant any temporary spousal support until such time as the court can have a hearing and review all of the factors that the court needs to do pursuant to Sparks and Louts. So that will be the order, Ms. Oatman, and you can prepare that and submit it under 7-day notice of entry.
Very good. Thank you, Your Honor.
Thank you. You're free to go.
Your
ahead.
Your Honor, I apologize. Could you broke up briefly on your stream? Could you please state the hours of parenting time again? It was Sunday at 12.
Until Tuesday at 8 o'clock p.m.
Thank
I
you,
guess
Your
the court would add too, I would add the standard holiday parenting time in the event that we don't get back in until, as the being that we're coming up on Memorial Day. And then the 4th of July, we might not be back in before that. So the court will alternate the standard holidays as well.
I will add that in. Thank you, Your
Okay,
Honor.
thank you.
Thank you.
Never trust a lawyer named iPhone. Also, you guys, I just had the pen. Where did I put it? I just had it. It's gone now. Honestly, I need it on a long thing. Where is the pen?
Does your client Ashley plan on appearing this morning?
Well, I got a message from her that said she was coming to my office, and last I knew she was not here, and even though we have a separate Zoom room set up for her, we can move ahead without her though.
Calling case 2024-1149 DC, Ashley Sprague versus Zachary Swanson. Today is Monday, May 13th, 2024 at 9:45 a.m.
Court will note the appearance of Ms. McNiff on behalf of plaintiff. The matter is before the court on plaintiff's motion for temporary custody, parenting time, and support. Ms. McNiff.
Thank you, Your Honor. Your Honor, when this case was first filed, there was a PPO in place due to a couple of incidents of domestic violence between the parties. Ms. Sprague set aside that PPO in order to try to co-parent in a better manner with Mr. Swanson. In addition, my understanding was that Mr. Swanson had been employed at Speed Rack in Quincy as a welder. He lost that job. I don't know if he's employed at this point or not. If he is employed, I don't know how much money he's making, what his income should be. The parties, to my understanding, have been exercising parenting time with Mr. Swanson having the minor child from Friday at 4 until Sunday at noon. And my client would like to maintain that schedule along with standard holidays. The child's young in this case. He's only a year old. So I would appreciate holding up yet on the summer vacation period until maybe we can get back into the court and make those determinations more about where Mr. Swanson is working, if he is working. He had been on a third shift job, which might be difficult to manage with a 1-year-old.
Okay. Mr. Swanson, what's your response to the motion?
Your Honor, I'm currently not working right now. I'm actually waiting on a phone call from a job, and
Oh, did we just see? Hold on. Is this a new one? He's literally on a phone call for a job right now. Usually they're applying for a job on Monday or they're just about to start. But is that what he's saying? Also, yes, I found the pen. Good night, Hector. Thank you, guys. I keep it in my bra or in my handy dandy apron that Cellulite Yoga Pants made me. But I obviously can't wear the apron all the time. Anyways, this whole day is confusing. Also, I'm not a huge fan of Attorney McSniff. No offense, Lisa.
I agree with what she says. So
Okay. So you're agreeable to the plaintiff retaining custody with you having parenting time the Friday through Sunday?
yes, Your Honor.
Okay. Well, that sounds like that's resolved then, Ms. McNeff. Court will grant, I'll grant to the parties temporary joint legal custody with physical custody, primary physical custody to your client, Ms. McNeff, with the parenting time from Friday at 4:00 p.m. through Sunday at 12:00 noon, as well as the alternating holidays at this particular point. The court will, what I will do, Ms. McNeff, is have the support can be set considering imputation to the defendant of $15 per hour. And you can, in fact, prepare a UCSO to that effect, as well as utilizing your client's income. Anything else, Ms. McNeff?
No, Your Honor. Thank you.
Mr. Swanson, anything else?
No, Your Honor. Thank you.
Okay. Thank you. You're free to go. Have a good day.
Yep, you too. Thank you.
This is the apron. Isn't it so nice? And it's very beautiful, custom sewn, and it's got a vape holder. She put one right here in the front. So it's perfect when I'm wearing this because it's got perfection. Whoa, Brandy, you look terribly sad. What's going on, dear? I think this is our last case for the night, you guys. I don't know that though. Yeah. Brandy.
David, can you hear me?
We can hear you.
Please unmute.
Oh, sorry, apologies. David is in my office with me, and if we have both microphones going, it creates an echo. And so he'll have to speak through my microphone, but he did say he can hear you.
All right, perfect. Calling case 2024-189 DC, David Bell versus Brandy Murray. Today is Monday, May 13th, 2024 at 9:49 a.m.
Well, I know for plaintiff, you're not Ms. Paisno. Would you identify yourself for the record?
Yes, good morning, Your Honor. Attorney Sydney Jordan here on behalf of Attorney Leslie Paisno, who represents the plaintiff David Bell, who is also present on Zoom.
Okay. And the defendant is appearing in pro per. This matter is before the court on the plaintiff's motion for temporary custody and parenting time. Ms. Jordan.
Yes, good morning, Your Honor. It is our understanding that the parties actually have a final agreement.
Okay,
And as such, we would request that we place that on the record this morning, and then my office will prepare the judgment accordingly.
that's fine. Go ahead.
So the parties would share joint legal and joint physical custody of the minor child. There is one minor child in this case, Sophia Isla Bell Murray, age 11 months old. The parties would request to exercise the right of first refusal only when one parent is working, and then the child would be returned after that parent's work shift. That there would be no child support ordered at this time for either party. The parties would exercise parenting time on a 2-week 2-2-3 rotation, beginning this week with mother having Monday, Tuesday, father having Wednesday, Thursday, then alternating the weekend. This would be Mother's Weekend, Friday to Sunday. Next weekend would be Father's Weekend, and rotating thereafter. That the parties agree to split holidays and special occasion parenting time by splitting the holiday itself, with one parent having the morning and one parent having the evening, or the first half and the second half. That this split would be by agreement of the parties, and that if they cannot agree, that in even years, Dad would have the first half of New Year's Day, Memorial Day, Labor Day, and Christmas Eve, with mother having the first half in odd years of New Year's Day, Memorial Day, Labor Day, and Christmas Eve. And then in odd years, father would have the first half of Easter, 4th of July, Thanksgiving, and Christmas Day. That Mother and Father's Day would always go to the mother or father. In this case, the parties are including the minor child's birthday in this holiday special occasion split/rotation. And I believe that that is the entirety of their agreement.
Okay. Ms. Jordan, do you know, are either of the parties on any public assistance?
Not to my knowledge, Your Honor.
Okay. Ms. Murray, are you receiving any public assistance for on behalf of minor child?
Yes, she is on Medicaid.
Okay, if she is on Medicaid, the court cannot waive child support, so there will have to be child support paid pursuant to the respective incomes of the parties.
Yes, Your Honor.
With that, Mr. Bell, is that your understanding of what the agreement is?
Yes, sir, Your Honor.
Okay, and you understand that you can't waive child support when public assistance is involved?
Yes, sir, Your Honor. I understand.
Okay. And you're agreeable to, again, an order which would recite the agreement as provided by Ms. Jordan?
Yes, Your Honor.
Okay. And are you doing so freely and voluntarily, sir?
Yes, sir.
Okay. Ms. Jordan, would you inquire of your client?
Yes, David, if you could please turn on your video, and then, Your Honor, if you would swear him in.
Oh, I'm sorry, that was Mr. Bell that was talking when I was asking Ms. Murray that.
It was.
Okay. Got him confused, okay? Ms. Murray, you understand the settlement is placed on the record by Ms. Jordan, as I clarified, as it relates to the child support?
Yes, Your Honor.
And is that agreeable to you?
Yes, Your Honor.
Okay, and you understand that if you'd have proceeded with the hearing, a different result could have occurred, could have been better result for you, a lesser result, or the same. And notwithstanding that, you agree to be bound by an agreement as set forth on the record.
Yes, Your Honor.
Okay, thank you. Looks like, Ms. Jordan, that your client's already agreed and put that on the record, so I'm not gonna need to do that. We don't need to have it sworn once it's put on the record any event.
Thank you, Your Honor.
Okay, Ms. Jordan, we'll leave that up to you. You can prepare the order, submit it to the other party, to Ms. Murray, and to the front of the court for approval, and then submit it to the court.
Excellent. If I might just briefly, Your Honor, Ms. Murray, do you have a good email address that we can use to send this to you?
Why don't you
Yes.
do this, Miss Murray, just so you don't put it on the record, so
Oh.
somebody has that? Because it is streaming. Would you provide Miss Jordan with that after your leave? Okay.
Thank you. We'll have my client reach out to you, Ms. Murray, with my email address so that you can provide it to council.
Okay.
Okay. Thank you.
Thank
Free
you,
to
Your
go.
Honor.
Have a good day.
Gilbertson and
More.
I do not have Attorney Lance in my waiting room. And this is on Anchor Hydro versus Power REIT at all.
And Marengo.
This is gonna be the last case.
Okay, bring him in, and maybe Mr. Lance isn't going to appear on this.
Please unmute. Calling case 2023-3145 CB Anchor Hydro versus Power REIT et al. Today is Monday, May 13th, 2024 at 9:56 a.m.
Court will note the appearance of Mr. Gilbertson on behalf of the plaintiff, Mr. Bolton on behalf of defendant in this matter. We have Mr. Lance in it, but he's not here. Could you enlighten me, is Mr. Lance intending to be here or doesn't need to? Because it's defendant Millennium's motion to set aside default and default judgment.
Good morning, Your Honor. For the record, Ian Bolton on behalf of Millennium Sustainable Ventures Corp. Your Honor, I do not believe Mr. Lance filed any response to the motion. I haven't spoken with Mr. Lance at all, and I don't believe he takes a position on this. My suspicion is he just didn't show up because he doesn't have anything to add. That being said,
Okay.
Your Honor, I didn't speak with him, so I'm not sure.
Okay, I'll just ask you, Mr. Bolton, you stated that the default and the default judgment were against a party that's name was incorrect. It's not your client's name. So if the judgment is not against your client, why do you need it set aside?
It's a really good question, Your Honor. I spoke with my client about this. You mean the name on the complaint differs from the name on the default judgment, differs from the name on the proof of service, differs from my client's name. But they're all really close. And I assume once they obtain the default judgment, they will try to collect on the assets of my client.
Well, being really close, as you know, in the law isn't accurate. So
I understand, Your Honor. The other option was just let them have their default judgment against this made up entity and good luck trying to collect on it.
yeah.
But I didn't want to fight it later. I thought if we know what they're trying to get to, so we thought we'd get it set aside and deal with it now. But that being said, Your Honor, if the court is of the opinion that just let them have the default judgment against the made up entity and then start over against my client one day, that's fine too.
Okay. Mr. Gilbertson, what's your thought?
Yes, thank you, Your Honor. Really the issue here is that the entities that have been named have all been identified by Mr. Bolton's CEO, his client, David Lesser, who's also the CEO of the other entities. So to the extent that he can't keep his entity's name straight and then now is using that as an umbrella to say, hey, you can't come after me because you had it misspelled or you had, also known as, and that's a sub-entity, not that, it's a complete shell game here. I think our response made that very clear.
Well, but the fact is you didn't get the default and the default judgment against the proper defendant. Is that accurate?
Well, the default judgment is against Millennium Sustainable Ventures Corp.
But the name is misspelled.
With one N, and that are multiple times back and forth in correspondence from Millennium Sustainable Ventures Corp with two N's in it. And those are the emails back and forth.
Well, regardless, I'm talking about the judgment. I don't care about any emails or correspondence or anything of that nature. The fact is you have a default judgment against an entity that is not a party to the case.
Your Honor, I think the case law we provided on misnomer is clear, that misspelling an entity's name by a letter when they have actual knowledge of the case does not render a default judgment as invalid.
Well, what happens is, in this case, is the court obviously wants it to be accurate, correct, I'm not gonna make those types of inferences in this and just assume that because somebody had misidentified or somebody got it right. I guess
Although we have heard judges say like that they'll amend things very easily. Lori, lovely to have met you. Thanks so much for being here. We hope you come back here every night. My daughter is almost 16, not a mechanic yet, maybe. But lovely seeing you. What an interesting night we've had. Judge is so freaking grumpy. So grumpy. Just so grumpy. I wonder how many I have so many unwatched videos of his that I'm just like, I know I'm sitting on some gold. I know. I should do like a grumpy compilation.
the only thing I can do, Mr. Bolton, is in this matter is the court is not going to set aside a default against a non-entity in this case. But if you feel better, the court would state simply that the plaintiff cannot execute against your client on this particular default judgment.
Okay, that works fine with me, Your Honor. I'll submit an order.
Okay, thank you. You can submit under 7-day notice of entry. Thank you, gentlemen. You're free to go. Have a good day.
All right, you too.
We all did. Oh, and he's done. He's done like dinner. So am I. Look at me. I know. The whole docket was full of crazy stuff. I hope you guys had a wonderful evening. A bit of a long one for us. I love this apron so much. I have on it my pin here that says, oh, by the way, if you're new here, when you see YouTubers doing this and then holding shit in front of their face, they're blocking their face from the camera so that you can read the thing where that one says, suck it up, buttercup. Oh, now I have to cough. Anyways, hold on. I'll mute myself and cough. That was a really interesting day. If you didn't see the other video that I posted today, go check it out. Leave a like and a comment. It's super helpful. Also, reminder, if you have any court that you want me to watch and you have a link or it's already downloaded or whatever, let me know. I'm here every night. Remember that I love you. I'm proud of you, and I will see you in the next video. Oh, and thank you to everybody who gave memberships and stuff today. I love you all. Thank you, thank you, thank you.